You may please resume your seats. Thank you so much. Ladies and gentlemen, my lords, my ladies, good morning. I am Umaru Sanda Amadou. I'm a journalist, but more importantly, I'm a product of the Central University where I did my LLB and currently in the final.
And co-MC with my colleague Umaru Sanda. We are here, ladies and gentlemen, as you are very much aware, for a colloquium on legal education reform in Ghana. We are here to consider how to implement the provisions of the Legal Education Act. How ready are the institutions under the acts? We shall be discussing accreditation in the future of legal education. Welcome. It is our prayer that you assist us run this program. It's a very bad program. And for purposes of time economy, we plead with you, or whoever it is that comes up here, to operate within time. Thank you so very much.
Shall we pray, please? Shall we be upstanding to pray? Almighty and everlasting Father, we thank you for the gift of life. We thank you, O God, even for the gift of this day. Oh Lord, you are worthy, O God, you are worthy to be praised. Thank you, O God, that all glory and honor belongs to you. Thank you that this day that we have anticipated, we have trusted you for, has come. And Father, take your glory, take your seat in the name of Jesus Christ. Let every proceeding be to the glory and honor of your name. We bless you. We give you praise. In Jesus' mighty name we pray with thanksgiving. Amen. Shall we please?
Thank you so much. If we could kindly be on our feet again or remain standing as we take the Ghana National Anthem, please. Thank you so much. Thank you so much. May we please resume our seats.
Ladies and gentlemen, we have begun the program. It is customary that for a program of this kind, we have a chair. We have already appointed one. And at this juncture, may I call for the introduction of the chairperson for this program.
The chair for today's colloquium is widely recognized as one of the pillars of legal education in modern Ghana. He has shaped not only the strategic direction of the Ghana School of Law, but also the strategic future directions of access to legal education, justice, and legal empowerment in Ghana and beyond. Educated at the University of Ghana, where he obtained his Bachelor of Laws and Master of Laws, he is the founder of Mount Crest University College, which established the first private law faculty in Ghana, opening the pathway for the underserved and non-traditional student. Starting his career in academia as a teaching assistant at the Faculty of Law of the University of Ghana, Mr. Ansah has taught in law faculties in Ghana and Nigeria. He has also assisted in curriculum revision in the Nigerian Law School and developed the curriculum of the Bachelor of Laws program for the University of Buea in southern Cameroon. Continuing as a lecturer in law at the Ghana School of Law from 1987 to 1992, Mr. Ansah was promoted to the rank of senior lecturer and elevated eventually to the position of Director of Ghana School of Law in the year 2002. A barrister and solicitor of the Supreme Court of Ghana since 1981. He is the founder of Ansah & Co. Hensel Chambers. He also served as legal consultant to the Committee of Experts that drafted Ghana's 1992 Constitution, playing a historic role in laying the foundations of the Fourth Republic. Ladies and gentlemen, the chair for today's colloquium is none other than Mr. Kweku Ansah.
Thank you very much. My Lord Chief Justice, His Lordship Mr. Justice Paul Abon, my lady, former Chief Justice Sofa Ekufu, my lords, Justices of the Superior Court of Judicature, Your Honors, Your Worships, Vice Chancellor, colleague, deans, learned friends, intending lawyers, Niemen, members of the Inky fraternity, students, ladies and gentlemen, good morning to you all. My Lord Chief Justice, the theme of the colloquium is implementing the Legal Education Reform Act 2025, institutional readiness, accreditation, and the future of legal education. I'm particularly grateful
for Central Law School, Central University, for inviting me to chair this historic colloquium on what we all know is the topic of the day amongst members of the legal profession, legal education. We are all assembled here, I believe, this morning as participants of the colloquium program hosted by this noble institution. Now, my emphasis is on Central Law School being a private university and therefore a private law faculty or law school. It means that it is not only the public law schools that can train the next generation of lawyers, but also private law schools. And more particularly, this being the first colloquium or several colloquia that have been assembled and are yet to be organized. Coming from a private law school, I'm particularly delighted that one day, one of the private law schools will position itself as leader in legal education in this country. And I commend the authorities of Central Law School for taking this bold initiative. Central University Vice Chancellor, Professor Ken Ajimatifa, thank you very much for showing the way. My Lord Chief Justice, distinguished audience, permit me to make a slight verbal modification at this point. I'd like to suggest the deletion of reform in the theme, living simply, implementing the Legal Education Act 2026, since that the reform has been enacted into law, and therefore the reform 2025 has become spent. And then we're left with institutional readiness, accreditation, and the future of legal training. That notwithstanding, the theme is act and fit for purpose. And again, I'm happy because her leadership, former Chief Justice of Kufu, is here. And I remember that in 2003, 2004, the General Legal Council mandated her leadership and retired Justice Atukuba to review the then Ghana School of Law curriculum and suggest a way for reforming legal education in Ghana, and in particular for addressing the issue of legality of the Ghana School of Law. That issue has now been addressed and under a current Chief Justice, so that the Ghana School of Law is now formally established by law pursuant to the Legal Education Act 2026, Act 1170. My Lord Chief Justice, the Legal Education Act 2020 reforms legal education. The central focus of which is that university law schools are now permitted to offer the professional law course. This means a far-reaching implication with the scrapping of the monopoly of the Ghana School of Law as far as the training of lawyers is concerned. Not only that, my Lord Chief Justice, entrance examination, the fearsome entrance examination for admission to the Ghana School of Law is now history, in the sense that it is statutorily abolished. Though majority of students are happy with the abolition, I think that it is a mistake for examination to be taken out of the mantle of students. It suggests that our students are examination phobia, which may not necessarily be the case. Any institution that does away with examination will itself not be fit for purpose. From time to time, we need to examine ourselves by first examining students we teach in order to ascertain whether what we have taught them have been imbibed and will be operational. And therefore, for me, sincerely, I do not share the enthusiasm and euphoria that entrance exam for admission into the law school has been abolished. One day, I can predict it will be reinstated. I'm sure about that. As you all know, this act that has reformed legal education and has actually enacted several institutional mechanisms into building a holistic legal education for Mother Ghana, I have always explained, is fit for purpose. I'm very excited about the reform in spite of my comments on abolition of entrance exam. I'm still very excited about the reform to legal education recently enacted into law. And I'm more than happy not only to chair, but be part of a historic colloquium to consider how, among other matters, to integrate the legislative changes into our program. As you all know, legal education remains close to our hearts because it has helped to set all of us here on the path we all are on now. Perusing the theme reassures me, my Lord Chief Justice, with the greatest respect, that speakers will make evidence-based suggestions and recommendations on how to structure accreditation, monitoring, staffing, teaching facilities and resources in order to structure a fit-for-purpose clinical legal education program, which is the philosophy underpinning the current program called CLET, as well as professional admission, post-qualification training, address complex and emerging challenges as part of our approach towards institutional readiness and the future of legal education in Ghana. I believe that speakers will also deal with the regulatory framework the roles of the Council on Legal Education and Training in Ghana, the role of the Ghana Tertiary Education Commission, compliance requirements, coordination challenges, program approval, and accreditation roadmap and curriculum in order to provide a pedagogy that will ensure that students and teachers alike understand and do appreciate the reform that has been enacted into Act 1170. My Lord Chief Justice, the expected output from the program with regard to institutional readiness, insights, draft accreditation roadmap, consolidated stakeholder recommendation, all call for integrity and honesty in implementing the reform. And standing in a building whose caliber is deeply rooted in faith, integrity, and excellence, I believe that by the time we exhaust the theme, we will all reassure ourselves, pat each other on the back, that in seeking to implement the roadmap enacted in Act 1170, all of us, each one of us, from the Chief Justice to the students, will be honest and approach the implementation with integrity, honesty, enthusiasm, zeal, and faith that the reform will succeed. I have confidence that it will succeed, provided all of us go about it in a way that will bring about integrity and excellence. And there's only one way to go, and that is faith. On this note, I accept the invitation to chair the function. And I thank Central University very much.
Thank you so much, Chairman. I think we can give him another round of applause. As media people, Dr. Zazar is our go-to person whenever we want to understand issues in the media related to legal matters, and he always helps us, and we are grateful. And I recall when the bill was passed and the presidential assent was given, I had an interview with him and he gave us an explanation. But I must say that we still receive calls from students who keep asking, so are we writing entrance exams? What happens to us? Am I going to remain at Central University or have to go to Makola? What happens to Makola? And so many other questions. And I think this colloquium is going to be the best platform for the education that we all need, the understanding, so that we can proceed thereof. Ladies and gentlemen, I want to do a quick introduction of some of our key dignitaries this morning. We have Dr. De Graft Kwanzaa. He is Vice Dean of the Central Law School. He was my dean, as Aluti said. Thank you so much. He was my project supervisor, and I'm happy I scored an A. Thank you, sir. We have Dr. Doreen Adomwa Eje, who is a lecturer at the Faculty of Law, KNUST. Thank you so much for joining us. Most appreciated. My own mother is here with us, Madame Juliette Eje. She's a registrar of the Ghana School of Law. Thank you so much. Her Ladyship, Justice Sophia Akufo, has made the time to join us this morning, former Chief Justice and also Chairman of the Advisory Board. Thank you so much, my lady. We're really grateful that you joined us. Nana Berima Yao Opon Kodia is a justice of the Court of Appeal, is a lecturer at the Ghana School of Law, and used to lecture here at Central Law Faculty. My Lord, thank you so much. And I have a confession that he's the one who forced me into law school. So, and I still remember, and I have to say this, my Lord, I didn't ask your permission. My Lord likes beautiful cars, or fancy cars, if you want to call that, or fast cars. When I needed to have my forms endorsed to come to Central University, he's a busy man. So we met, he said, listen, I'm going to teach at Mutual. I'm also busy going on air. So we met around the Palace Mall, and he signed my documents on the hood of his car. And I'm grateful that when I went to the Ghana School of Law, he was the director. My Lord, most grateful that he joined us. Thank you. Professor Kenneth Tefwa, in the media circles again, we used to call him criminologist, not a criminal lawyer. I don't know why they coined that title for him. He's been very much involved in giving legal education in the media space. Currently the Dean of the Faculty of Law. Prof, thank you so much for being with us and inviting us as well into your home. We have Professor Kwesi Dateba, who is the Vice Chancellor of the Central University, our headmaster. Thank you, sir, for inviting us. Ladies and gentlemen, this morning, a very really busy morning, but the number 4 gentleman of the land has made it to join us here, to celebrate with us, and also to help teach us. Ladies and gentlemen, with a standing ovation, I think we should rise up and salute His Lordship, the Chief Justice of the Republic of Ghana, Paul Bafokodi. Thank you so much. We are grateful, Father, for joining us. Thank you so much. We may please resume our seats. And let me also inform you that this program is live on all the social media platforms of Central University. And so those who are not here with us are following proceedings and learning as much as they can. Ladies and gentlemen, we move on to the next item on the agenda, and it has to do with an introduction. Let's go to the screens. Thank you.
The brainchild and host of this all-important colloquium, Professor Kenneth Agyemang Atefa, a distinguished lawyer, notary public, criminologist, sociologist, human rights expert, governance specialist, and an exceptionally engaging communicator. He is a public sector reform leader with extensive national and international experience in law, public administration, digital identity systems, refugee protection, transitional justice, and institutional development. Widely regarded as a high-impact influencer and institutional renewal agent, he is noted for his policy innovation and transformational and thought leadership prowess. From February 2017 to November 2024, Prof. Atefa served as the Executive Secretary of the National Identification Authority, NIA, where he led the transformation of Ghana's national identity ecosystem into a modern, technology-driven platform supporting the country's digitalization agenda. Currently, Prof. Atefa serves as Dean of the Central Law School at Central University, having been reappointed in December 2025. He previously served as the founding dean of the same school from March 2014 to February 2017. He was also an associate professor of governance and leadership at the Ghana Institute of Management and Public Administration, GIMPA, where he contributed significantly to the establishment of the GIMPA Law School. Ladies and gentlemen, please let's welcome the Dean of the Central Law School, Professor Kenneth Agyemang Atefa.
Your Lordship, Justice Paul Bafuboni, Chief Justice of the Republic of Ghana, and our keynote speaker. Your Ladyship, Justice Sofa Abina Boafu Akufu, former Chief Justice of the Republic of Ghana and Chairperson of the Central Law School Advisory Board. My lords, my ladies, temporal and majestic, Professor Kwesi Databa, Vice Chancellor of Central University, Professor Stephen Abine Mixon, Pro-Vice Chancellor, Central University, Mrs. Lily Yabua Nutaku, Registrar, Central University, Mrs. Juliet Edu Eji, Registrar, Ghana School of Law, representing Professor Raymond Atuguba, Director of Legal Education, Mr. Kweku Ansanasari, Dean of the Faculty of Law, Mount Crest University College, and Chairperson of this colloquium, Barima Yao of Hong Kong, former Director of the Ghana School of Law and Justice of the Court of Appeal, Mrs. Victoria Nana Amabaf, Vice President of the Ghana Bar Association, Dr. Kweku Ajimanbudu, Dean, Gimpa Law School, Mr. David Asunda, Dean, Faculty of Law, Pentecost University, Mr. Anthony Forson, Jr., former President, Ghana Bar Association, Professor Augustine Oglu, Deputy Director General, Ghana Tertiary Education Commission, Honorable Justices of the Superior Court of Judicature, members of the Central Law School Advisory Board, representatives of the Council on Legal Education and Training, deans, faculty members, and representatives of law schools and faculties across Ghana, members of the Ghana Bar Association, my Vice Dean, and colleagues of the Central Law School, leaders of the Central Law Students Union, and student representative councils from sister law schools and faculties, our cherished students of Central Law School, distinguished ladies and gentlemen. Good morning once again, and a very warm welcome to Central University and Central Law School. It is a singular honor and privilege to welcome this distinguished gathering of judges, regulators, legal practitioners, academics, university administrators, students, and other stakeholders in legal education to this national colloquium on the theme Implementing the Legal Education Act, Legal Education Act 2026, Act 1170, institutional readiness, accreditation, and of legal training. The caliber of participants assembled here today underscores the national importance of the subject under consideration. We are particularly honored by the presence and participation of His Lordship, the Chief Justice, Justice Paul Bafuboni, who will shortly deliver the keynote address on the vision, structure, and national expectations underlying the new legal education framework. We are equally privileged to welcome Her Ladyship, Justice Sofa Abina Boafu Akufu, former Chief Justice of the Republic and Chairperson of the Central Law School Advisory Board. Her steadfast commitment to legal education, constitutionalism, and the development of the legal profession continues to inspire the legal community and enrich our institutional journey at Central Law School. I also wish to acknowledge the invaluable support and participation of the members of the Central Law School Advisory Board. Their wisdom, experience, and strategic guidance will be instrumental in our efforts to position Central Law School as a center of excellence in legal education and professional training. We are delighted to welcome colleagues from law faculties and law schools across the country, members of the bench and bar, representatives of regulatory institutions, members of academia, and the leadership of student bodies represented here today. Your participation reflects a collective commitment to shaping the future of legal education in Ghana. Ladies and gentlemen, the enactment of the Legal Education Act 2026, Act 1170, marks a watershed moment in the evolution of legal education in Ghana. It represents easily the most significant and audacious reform of our legal education system in our history. It also signals a deliberate national effort to expand opportunities for legal training, strengthen quality assurance, improve professional legal education, and better align training with the demands of a rapidly changing society. For Central Law School and our sister institutions, the Act presents both tremendous opportunities and important responsibilities. It challenges us to rethink traditional approaches to legal education, strengthen institutional capacity, modernize curricula, enhance infrastructure, invest in faculty development, and ensure that our graduates are equipped not only with legal knowledge, but also with the practical competencies, ethical foundations, and professional values required for effective legal practice and public service. It is against this background that Central Law School convened this colloquium. Our objective is not simply to discuss a new statute. Rather, we seek to create a national platform for informed dialogue, collaborative problem solving, and strategic planning concerning the implementation of Act 1170. The objectives of the colloquium are therefore fourfold. First, to deepen stakeholder understanding of the provisions, implications, and implementation requirements of Act 1170. Second, to examine the readiness of legal education institutions to meet the governance, accreditation, quality assurance, and operational requirements contemplated by the new legal regime. Third, to explore practical ways towards accreditation, compliance, and institutional sustainability in the emerging legal education landscape. Fourth, to facilitate a forward-looking conversation about the future of legal education in Ghana, including curriculum innovation, faculty development, infrastructure enhancement, technological adaptation, and the preparation of lawyers capable of responding effectively to contemporary national and global challenges. Today's program has therefore been carefully structured to move from vision to implementation. Through the keynote address, expert panel discussions, paper presentations, and stakeholder engagement sessions, we will collectively examine the regulatory framework, accreditation requirements, curriculum reforms, faculty development needs, infrastructure requirements, and broader institutional readiness considerations that must inform successful implementation of the Act. As a law school, we regard this colloquium as part of our contribution to the national conversation on legal education reform. Universities must not merely respond to reform, they must actively help shape its success. We therefore hope that today's deliberations will generate practical recommendations, institutional readiness insights, accreditation roadmaps, and strategic priorities that will contribute meaningfully to the successful implementation of Act 1170. My lords, temporal and majestic, ladies and gentlemen, the future of legal education in Ghana is being shaped today. The conversations we have, the ideas we exchange, and the partnerships that we build during this colloquium will have lasting implications for future generations of lawyers and for the administration of justice and the rule of law in our country. I therefore encourage all participants to engage actively, contribute thoughtfully, and collaborate constructively as we work together towards a shared vision of excellence in legal education. I thank you for your attention, and may God bless our land, Ghana. Thank you very much.
We can do it again for Prof.
Thank you very much, Professor Ken, at the Manate Central Law School, and may history be kind to you and the institution that you lead for gathering legal minds to discuss the future of legal education in Ghana. Ladies and gentlemen, I have instructions to announce the presence of Professor Stephen Abini-Nixon. I'm told
Prof is here. Prof is the Pro Vice Chancellor, Central University. Prof, if you are here. Thank you very much. And then we also have Mrs. Lee Lutako, Registrar, Central University. I'm further instructed that there are deans, other of entities in the school, deans and directors, if you be waved so that we see that you are here. And somebody, a student said that once the deans are here, there was a high dean. Ladies and gentlemen, it is an honor for me to invite the landlord of the university. May I now call for the introduction of Professor Kwesi Dateban, Vice Chancellor, Central University, for his opening remarks. The introduction.
Professor Kwesi Dateban, a distinguished scholar, accomplished academic leader, and Professor of Leadership and Organizational Development. He currently serves as the Vice Chancellor of Central University, where he provides strategic direction for institutional growth, innovation, and academic excellence. He also contributes to regional higher education advancement as a member of the Strategic Committee of the West African Hub of the Education Collaborative, supporting initiatives to strengthen universities and improve student outcomes across West Africa. With a career spanning academia, engineering, consultancy, and executive leadership, Professor Dateban is widely respected for his expertise in leadership, organizational transformation, and strategic management. Prof. Dateban's multidisciplinary and international academic background underpins his work. He holds multiple doctoral degrees in leadership, human resource development, and business management from institutions in the United States, United Kingdom, and South Africa. He also earned a civil engineering degree from Imperial College London, providing him with a strong analytical and systems thinking foundation. Ladies and gentlemen, Let's welcome the Vice Chancellor of Central University, Professor Kwesi Jateba.
Good morning, ladies and gentlemen. I would like to associate myself with the protocols already established. It is my pleasure and privilege to formally welcome you all to Central University and to this important national colloquium on the implementation of the Legal Education Act 2026 Act 1170. Today, we gather at what I believe is one of the most consequential moments in the history of legal education in Ghana. Every generation is presented with a defining opportunity to rethink institutions that have served the nation well, but must now evolve to new realities. This is the moment. The passage of the Legal Education Act 2026 represents more than a legislative reform. It represents a national conversation about access, excellence, professional competence, collaboration, and the future of justice in Ghana. The reform seeks to modernize legal education governance, widen opportunities for professional training through accredited institutions, and maintain rigorous national standards through a unified system of professional assessment. The question before us is therefore not whether reform is necessary. The question is whether we are ready. Are our institutions ready? Are our regulators ready? Are law faculties ready? And perhaps, most importantly, are we ready to prepare lawyers for the Ghana of tomorrow rather than the Ghana of yesterday? At Central University, we welcome the opportunity to contribute meaningfully to the next chapter of legal education. However, let us be clear. The objective of the Act cannot simply be to produce more lawyers. The objective must be to produce better lawyers. Lawyers who are ethically grounded. Lawyers who are technologically competent. Lawyers who understand not only statutes and precedents, but also the social realities of the people they serve. Lawyers who see the law not merely as a profession, but as a public trust. As we expand access, we must preserve excellence. Indeed, one of the greatest lessons of educational reform worldwide is that access without quality is dangerous. Quality without access is exclusion. The future demands both. This is why today's discussion on institutional readiness and accreditation is so important. Accreditation is not merely an administrative exercise. It is a covenant with the nation. It is a commitment that every institution entrusted with legal training possesses the faculty, infrastructure, intellectual resources, ethical culture, and practical orientation key to producing competent professionals. Ladies and gentlemen, the lawyer of the future will practice in a world transformed by artificial intelligence, digital commerce, cybersecurity challenges, cross-border transactions, and rapidly evolving regulatory systems. Legal education must therefore become more innovative, more practical, more interdisciplinary, more collaborative, and more responsive to the needs of society. The future of legal education is not about opening more classroom doors. It is about opening more doors to justice. And that future begins with the decisions we make today. As a university committed to academic excellence and national development, Central University stands ready to support this important national agenda. We stand ready to collaborate with regulators, the judiciary, the legal profession, and fellow institutions to ensure that the implementation of this reform achieves its intended objectives. Because ultimately, legal education is not merely about training leaders or lawyers. It is about strengthening the rule of law. It is about protecting rights. It is about deepening democracy. And it is about shaping the future of our nation. In closing, permit me to leave you with this thought. The Legal Education Act must not mark the conclusion of change, but rather the commencement of a new era. The success of this reform will not be measured by the law we passed. It will be measured by the lawyers we produce, the justice they advance, and the nation they help build. I thank you for your patience and participation, and it is now my pleasure to officially declare this colloquium open. Thank you very much. God bless Central University, and God bless the Republic of Ghana. Thank you.
Thank you so much, VC. We really appreciate it. Thank you. Let me say that we are coming to the end of the opening session, but we still have a lot more happening today. We have 3 panel discussions happening, one on legal and regulatory framework. We also have another panel discussion on accreditation and institutional readiness, and then we have one on curriculum, faculty, and infrastructure. All of that happening today. But the opening session would be climaxed by the keynote address, and I do not have locus. Locus is very important. I do not have locus to introduce the person who's going to give us a keynote address, but it's going to speak on the topic implementing the Legal Education Act 2026, Act 1170, or Act 1170, Vision, Structure, and National Expectations. Ladies and gentlemen, you're going to hear the proper introduction of our speaker from the person with the locus to do so. Thank you so much.
Keynote speaker for this important colloquium, His Lordship Justice Bafubon, a seasoned Ghanaian jurist with an extensive legal career spanning over 3 decades, a native of Goso, who began his education at the Roman Catholic primary school. Through sheer determination and hard work, he successfully sat for and passed the common entrance examination, which led to his admission to Konongo Odumasi Secondary School. There, he excelled in both his O and A-level examinations. Justice Bafuboni is a distinguished alumnus of the University of Ghana, where he studied at the Faculty of Law, and he furthered his legal education at the Ghana School of Law. His illustrious career has seen him serve in various capacities across Ghana's judicial system, culminating in his appointment as a Justice of the Supreme Court of Ghana 17 years ago in the year 2008. Prior to this, he served as a Justice of the Court of Appeal and the High Court, as well as a Circuit Court Judge. Before ascending to the bench in the year 1992, Justice Bafuboni held significant leadership roles within the Internal Revenue Service and the Ghana Prison Service. Our keynote speaker has been an influential figure in legal education and judicial reform, with expertise spanning constitutional law, judicial ethics, taxation, prison administration, election law, and legal education. He chairs and serves on several key committees, including the Disciplinary Committee of the General Legal Council and the Election Management Committee of the Judicial Service of Ghana. His experience also extends to international judicial cooperation, having participated in global conferences and capacity building initiatives. Our keynote speaker is renowned for his integrity, dedication, and excellence to judicial administration, as well as his unwavering commitment to upholding the rule of law in Ghana. He is a mentor to many within the judiciary and advocate for continuous professional development and ethical practice. An avid sport enthusiast, a supporter of Accra Great Olympics and Liverpool. Currently, he is the most senior and longest-serving Justice of the Supreme Court, continuing to leave an indelible mark on the legal landscape of Ghana. Ladies and gentlemen, Central University, Ghana as a whole, let's welcome our keynote speaker for this important colloquium on legal education in Ghana, His Lordship, Justice Paul Bafuboni.
This long introduction, please. It is said about me, all the things said about me, the ones I like is the fact that I come from God in the life of wisdom. Those days, if you were asked to, students were asked to describe an aeroplane, it was just for imagination for what it was. So we always told ourselves that we were handicapped. Because when we write essays and examinations, students or pupils in other elementary schools in Accra, some of them have been traveled on the airplane. They had seen it first at hand. They had traveled with it, and some of them had even had the benefit of being in the cockpit
and we're all to write the same examination about the error. It was a difficult thing, but we managed to get here. So if I hear, then it tells you that hard peace. And so students here, you should take a leaf from not I alone. I know a particular Supreme Court judge doesn't know whether he is an old girl, even though he's a man, whether he should describe himself as old girl from school or an old boy. It's lost just in the I want to go to my secondary school. And if you think it's a village school, then his lost just the next day went to Shabu Secondary School. I don't know how we could have met you. It used to be a mixed school. And now that we turned into a first level secondary school, it's now a girls' school. So we don't know whether to describe him as an old girl from school. But that is what they say. The highest that great men reached the kids was not attained by sacrifice. But they were their opponents were friends were toiling hours in the night. This is part of the speech. I just want you to know that you can make it to whichever level that you want to. Where you are coming from is not as important as where you want to go to. I know some of you might have wanted to take or Lagos or whatever, but you are here and you have produced some of the very good lawyers of late. So you will take a leaf from them. Now let me return to my speech. Chairperson Colloquium, my classmate and friend, your leadership, the former Chief Justice Sophia distinguished members of the bench bar, representatives of the Council of Legal Education and Training, officials of the Ghana Tertiary Education Commission, the Vice Chancellor and Managing Ministers of Central University, the Dean, Vice Dean, Faculty of Central Law, distinguished scholars, legal practitioners, students, ladies and gentlemen. There are moments in the life of a nation when a new law does more than change rules. It becomes a bold declaration of who you choose to be. Today, we are not here simply to debate technicalities of implementation. We stand at the threshold of a genuine transformation in how Ghana prepares custodians of justice for the future. I am deeply honored to join you at this important national colloquium, organized by the Central Law School of Central University. I want to congratulate the organizers for their foresight, intellectual qualities, and genuine commitment to our nation's legal future. By convening this gathering, you have shown the kind of leadership our country needs. One that does not merely teach the law, but dares to issue it. The theme before us, implement the Legal Education Reform Act 2026, Act 1170, is both timely and finding consequential. It invites us to reflect honestly on the standards we must uphold, the reforms we must courageously embrace, and the institutional culture we must build if our legal system is to fully serve the constitutional dreams of our republic. This conversation goes far beyond establishment. It is about national transformation. It is about widening access to professional legal training without compromising excellence. It is about creating a system that is fair, transparent, rigorous, technologically smart, and deeply rooted in our national realities. Above all, it is about forming a new generation of lawyers who are not only competent, but ethically grounded, socially conscious, and ready for the complex demands of the 21st century. For many decades, Ghana's legal education system has produced some of the finest jurists, advocates, academics, and public servants on the African continent. Our legal tradition has long been admired for its intellectual depth, professional discipline, and unwavering integrity. Yet, as every living institution must do, we paused and listened to the voice of our people. Growing public concern emerged about access, capacity, transparency, and relevance. Too many talented individuals found their dreams stalled at the gates of professional training. Questions persisted about consistency in our admissions, accreditation processes, and institutional coordination. Curriculum needed urgent modernization to address emerging areas such as technology, international commerce, and environmental law. Above all, there was an institutional call for greater fairness, accountability, and equal opportunity. These concerns sparked sustained national dialogue involving the Commission, the Ghana Bar Association, universities, parliaments, students, and civil society. So the enactment of Act 1170 therefore represents a mature and thoughtful national response, a bridge between our proud legacy and the future we must now build. As Chief Justice Obasal famously declared the landmark case of Marvel vs. Watson, it's emphatically the province and duty of the judicial department to say what the law is and but for the judiciary to fulfill this sacred duty, we must first ensure that those who appear before us and those who will one day sit on these benches are properly informed. That foundation begins in our law schools. At its core, Act 1170 is revolutionary in its balanced ambition. It
seeks to achieve five interconnected objectives that will redefine legal training in Ghana. First, expanding access to professional legal education. For far too long, institutional limitations frustrated thousands of qualified graduates. This act democratizes opportunity. It creates a more decentralized yet regulated system of academic institutions operating under clear national standards. In doing so, it honors the constitutional principle of equal opportunity, recognizing that competence and merit, not artificial scarcity, should determine progress. Second, preserving professional standards. We must be unequivocal. Access must never be lowered to standards. Let me repeat that. We must be unequivocal. Access must never be lowered to standards. Lawyers are officers of the courts, guardians of constitutionalism, protectors of rights, and custodians of the law. Act 117 therefore establishes robust mechanisms for accreditation, quality assurance, curriculum standards, and regulatory oversight to ensure that excellence remains non-negotiable. Third, fostering institutional clarity and coordination. The Act brings greater precision to the rules of the Council for Legal Education and Training declares. The Ghana Teachers Education Commission, DTEC, universities, and other stakeholders. It replaces uncertainty and overlap with structured collaboration because competition amongst institutions must be matched by cooperation and mutual respect. Permit me at this stage to emphasize a matter that is sometimes overlooked whenever discussions about legal education reform arise. The success of Act 1170 will not depend solely on legislation, accreditation standards, or institutional infrastructure. It will depend equally on the spirit in which our institutions choose to engage one another. The expansion of legal education should not produce isolated center of excellence, operating as competitors in perpetual rivalry. Rather, it should encourage the emergence of a community of law schools united by a common national purpose. Note that competition has its place. It encourages innovation. It motivates institutions to improve facilities, strengthen academic programs, attract talented faculty, and enhance students' outcomes. Healthy competition can be a powerful force for progress. But legal education is entirely to competition. The responsibility of preparing future judges, advocates, legislators, prosecutors, academics, diplomats, corporate counsel, and public servants is a national responsibility. No single institution can shoulder that burden alone. No law school, however distinguished, possesses a monopoly on wisdom, expertise, or innovation. For this reason, I believe the future of legal education in Ghana must be characterized not merely by institutional excellence, but by institutional cooperation. Our law faculties must increasingly see one another as partners in a common enterprise. There should be opportunities for collaborative research on pressing national issues. Faculties should work together on questions relating to constitutional development, judicial reform, environmental governance, artificial intelligence, commercial regulation and corruption strategies, natural resources management, and access to justice. Joint conferences, shared academic programs, faculty exchanges, collaborative publications, and inter-university moot competitions should become regular features of our legal education landscape. And let me take that again. Joint conferences, shared academic programs, faculty exchanges, collaborative publications, and inter-university moot competitions should become regular features of our legal education landscape. Senior academics in one institution should be able to contribute to the growth of another. Distinguished practitioners and judges should be encouraged to support legal education across institutions rather than within a single institutional silo. The development of legal education in Ghana should not be viewed as a contest between universities. It should be viewed as a collective national undertaking. Indeed, one of the greatest indicators of institutional maturity is the willingness to share knowledge. When institutions cooperate, students benefit. When students benefit, the profession benefits. When the profession benefits, the administration of justice benefits. And when justice is strengthened, the nation benefits. Act 1170, therefore, presents us with an opportunity not only to expand legal education, but also to cultivate a culture of intellectual partnership among our law faculties. The future demands nothing less. Fourth, modernizing legal education. The legal profession is transforming rapidly. Artificial intelligence, fintech, cybercrime, data protection, and global arbitration are reshaping practice. The lawyer of tomorrow must be technologically literate, commercially aware, clinically skilled, and globally competitive. Act 1170 opens the door for curriculum reform, stronger clinical education, digital infrastructure, and interdisciplinary training. The fifth is strengthening public confidence. Legitimacy flows from trust. Citizens must believe that legal training is fair, transparent, merit-based, and ethically sound. This act seeks to replace opacity with accountability and excellence. This vision echoes the profound vision in Casavanida Bandit versus State of Kerala, where the Indian Supreme Court reminded us that certain basic structures of governance and justice must remain inviolable even as societies evolve. We too must protect the basic structures of professional competence while courageously expanding access. Act 1170 establishes a comprehensive architecture, a strengthened council for legal education and training, clear governance structures, accreditation standards, quality assurance mechanisms, and provisions for institutional sustainability. Yet we know this truth deeply. Laws do not implement themselves. Institutions do. The success of this framework will depend on the integrity, discipline, and professionalism with which we breathe life into Act 117. Across the nation, legitimate expectations have risen. Students expect merit-based pathways. Universities seek clarity. The legal profession demands competent, ethical, and practice-ready graduates. The judiciary expects advocates who understand courtroom ethics, procedural rigor, and their constitutional responsibilities. These expectations are fair, and they come with shared responsibilities. The central question before us today is one of genuine readiness. Governance and regulatory preparedness must be substantive, not symbolic. Institutions must build credible structures that guarantee academic integrity, financial accountability, and professional discipline. Regulators must ensure accreditation processes are objective, transparent, and timely. Faculty capacity is critical. We must invest in recruiting and developing outstanding lecturers, practitioners, clinicians, and mentors. Continuing legal education for faculty themselves must become the norm. Infrastructure and resources can no longer be an afterthought. We need modern lecture facilities, well-equipped libraries, digital databases, moot courtrooms, clinical centers, and technology-enabled learning environments. The era of relying solely on traditional lectures is behind us. Ethical and professional formation remains the heart of the matter. We must never reduce legal education to the mere transmission of rules. Law is a public trust. Integrity, civility, honesty, respect for the courts, and fidelity to constitutional values are indispensable. As Oliver Wendell Holmes observed, the life of the law has not been logic, it has been experience. That experience must include the ethical formation of character. Now, the role of the judiciary and the need for collaboration. As we reflect on the future of legal education, it is useful to remind ourselves that the idea of legal training as a national project is not new. It is deeply rooted in the aspirations and accompanying Ghana's emergence as an independent state. As far back as 1963, when the first batch of locally trained lawyers graduated from the Ghana School of Law, our first president, Osajifo Dr. Kwame Nkrumah, understood that political independence could not be sustained without strong national institutions. He recognized that the administration of justice, the development of constitutional governance, and the building of a modern state required a cadre of highly trained legal professionals committed to national service. For Nkrumah, legal education was never intended to be merely a pathway to professional advancement or personal success. It was a nation-building enterprise. The newly independent states required lawyers who could draft legislation, shape public institutions, advise governments, defend constitutional principles, negotiate international agreements, resolve disputes, and contribute to the social and economic transformation of the country. In that vision, the lawyer occupied a unique place in national life. The lawyer was not simply an advocate in the courtroom. The lawyer was expected to be an architect of the institution. The lawyer was expected to be a guardian of public order. And the lawyer was expected to be a defender of justice and a servant of the public good. The understanding partly explains why legal education occupies such an important place in the broader project of national development during the formative years of our republic. Nkrumah also appreciated the importance of ensuring that legal education reflected the realities and aspirations of Ghanaian society. While our legal system inherited valuable traditions from the Commonwealth, from the common law, independence demanded something more than inheritance. It required adaptation. It required innovation. It required the development of legal thinking capable of responding to African realities and African challenges. Legal education, therefore, had to produce lawyers who understood not only legal doctrines, but also the social conditions within which the law operates. It had to produce lawyers who could appreciate the relationship between law and development, law and governance, law and economic transformation, law and social justice. That vision remains remarkably relevant today. The challenges confronting contemporary Ghana are different from those of the 1950s and 1960s. We now grapple with cybercrime, artificial intelligence, cross-border commerce, environmental degradation, digital regulation, financial technology, data protection, and increasingly complex and constitutional questions. Yet, the underlying need remains unchanged. Our nation still requires lawyers who possess intellectual excellence. Our nation still requires lawyers who are guided by integrity. Our nation still requires lawyers who understand that law is not merely a profession, but a public trust. Our nation still requires lawyers. Our nation still requires legal education that produces leaders capable of strengthening institutions and advancing the collective national interests. Viewed in this light, Act 1170 is not a departure from our national aspirations. It is in many respects a continuation of them. The expansion of access to legal education, the strengthening of quality assurance mechanisms, the promotion of professional competence, and the commitment to institutional accountability all seek to advance common objective, ensuring that Ghana has the legal talent necessary to sustain constitutional democracy and national development. As we implement this reform, we must therefore keep before us a simple but profound question. What kind of lawyer does Ghana need for the future? The answer cannot be limited to technical competence alone. Ghana needs lawyers who are intellectually rigorous, yet ethically grounded. Lawyers who can compete globally, yet remain committed to national service. Lawyers who understand technology, but are guided by humanity. Lawyers who can defend rights while strengthening institutions. Lawyers who appreciate that the rule of law is not merely a legal doctrine, but one of the foundations upon which democratic societies are built. If our implementation of Act 1170 succeeds in producing such lawyers, then we would not merely have a reform. We would not merely have reformed legal education. We would have strengthened the future of the Republic itself. As Chief Justice, I want to assure all stakeholders that the judiciary is fully committed to reforms that strengthens legal education and the administration of justice. The quality of advocacy directly affects the quality and speed of justice delivery. Poor training burdens the courts and erodes public confidence. Excellent training strengthens constitutional governance and deepens trust. Again, implementation must never become an arena for rivalry or suspicion. This is a national project. The bench, the bar, universities, regulators, students, and government must work together in good faith. Reform flourishes where dialogue replaces division and collaboration replaces fragmentation. We must avoid the false choice between access and standards. Ghana can and must achieve both. We must approach implementation with vigilance, resource constraints, faculty shortages, quality assurance difficulties, and the temptation of commercialization of competence are real risks. Accreditation must never become a mere formality. Expansion without quality control will damage the profession and public trust. Yet, I remain profoundly optimistic. If we implement Act 1170 with wisdom and courage, we can 1. Expand opportunities for talented young Ghanaians. 2. Elevate professional training through innovation and specialization. 3. Strengthen clinical and practical education. 4. Promote research and scholarship. 5. Deepen ethical culture. And finally, position Ghana as a regional leader in legal education. Distinguished ladies and gentlemen, the future of Ghana's legal profession will be shaped significantly by the choices we make today. Let us implement these reforms with wisdom. Let us preserve standards with integrity. Let us expand opportunity with fairness. And let us build a legal profession that truly reflects the constitutional ideals of our republic. One that produces lawyers worthy of defending justice, liberty, and the rule of law. Once again, let me commend the Central Law School for this initiative and encourage all participants to engage with openness, honesty, and national commitment. I thank you for your attention. May God bless us and bless our homeland, Ghana.
Can we please give a round of applause? My Lord Chief Justice, thank you so much. We are most grateful. The first session of this program has effectively come to an end. We have 3 panel discussions, like I mentioned to you earlier, which is going to happen next. But before then, there's a photo session where my Lord Chief Justice and my lords and ladies would come up front kindly for a group photo. After that, my ladies and my lords would see off my Lord Chief Justice, and then the second part of the program would commence. So, if you could kindly indulge us. Camera crew, are we ready? Where's the best place for the photograph? Can we do it here? Camera crew, is this place good? All right. I'm advised that we can kindly come up front on the steps for the photo session. Thank you so much. Yes, please. So kindly come up to the steps. So you kindly face the audience and the camera crew will do the photography. Registrar of the Ghana School of Law, please join us. Vice. All right, thank you so much. Most grateful. So the Chief Justice will take leave of us, and then we continue with the rest of the program. My Lord Chief Justice, thank you so much. We're most grateful. Okay. All right, so can we reconfigure the platform, the stage for the panel discussion? Technical team, can we reconfigure the stage for the next session, the panel discussion that will be happening next? Our students from Mutual, you are welcome. I hear that bone traffic affected you. We are grateful that you made it to join us. Thank you so much.
While the stage is being configured for the panel discussion, a few announcements I want to make. After the announcements, you may want to rise and stretch a little and then sit down again, because the discussion will be following soon. I have been instructed to announce to you, especially those who are not familiar with this place, that there are washrooms here. If you want to go and do what you want to go and do, you can speak to any of the ushers. I have also been informed that there is an ambulance waiting just in case any one of you is here and wants to. Yeah. Okay, so National Ambulance, the personnel are here. And the ambulance itself is also here. So just in case you feel like being driven in the ambulance, that will be fine. And yes, I think that's that. So you can rise and then stretch a little, maybe some brief tech break. You can make a call, take a selfie, send to somebody you are here. This program is historic, and you must have a record that you were part of the people that met and then discussed the Legal Education Act. So you are permitted to take a picture and a selfie and send. But make sure it doesn't fall into the hands of your enemies or those who are trailing you to get you out from becoming a lawyer. Yes, I remember when we were in the law school, one of my mates told me never to tell anybody that he was in the law school, because he knows his home people and what they are capable of doing. If they get to know that he was in the law school, that may be his end. And yes, interestingly, he couldn't make it. So I don't know, but I'm not the one who sent information that he was in the law school. Yes.
There are people who also said to me, when I got admission, they said, when you go, wear a nose mask and sit at the back, and don't let anybody know you are in the law school. Unfortunately for me, my forehead is so long, I cannot hide. So I have been identified. And I'm also too known, so I like to make noise. But getting admission to the Ghana School of Law is a big deal. So when you get it, you have to let the world know. And so I look forward to seeing all of you who are in your final year, especially when you finish. And then I don't know what's going to be. Are you going to continue here or you go to Makola? We'll be finding out. All of that and more going to be part of our discussion next. So let's just take a minute break, stretch, and then we constitute our panel for the conversation to start. Just a minute so that we can just set up the stage. Thank you so much. But please don't go far, just a minute. If you need to use the washroom, you go out and it's on your right. Yes. But otherwise, our dignitaries are back, so we are just about to take off. You don't have to go far. Thank you. So can we start taking our seats, please, so we can go to the next session? Can we resume our seats, please? Make sure there's no empty seats before you, in front of you. Let's fill up all the seats. Ushers, can we get those who are outside to come in so we can continue? Ushers, can we get the audience back at their seats so we can proceed? take our seats, please? Kindly take your seats. Let's proceed. Please take our seats for the continuation of the program. Ushers, can you help us, please? Let's get people back to their seats. Those at the back, can you please take your seats? Ushers, make sure everyone is in their seat, please. All right, can we please take our seats so we continue with the program? Ushers and organizers, please help us with that from the back. And try and make sure there's no empty seat in front of you. If there are empty seats in front of you, please fill them up. All right, control room, can we have some silence now so we start? Very well, thank you so much. Good morning once again. If you're just joining us for this colloquium, we are most welcome. We really appreciate you. We've had the first session of the program where we have had the keynote address. We're going to have 3 panel discussions happening today. We want to understand what the legal education really means, the new bill that has been passed, and what the consequence thereof is. I am Umaru Sanda Amadu. I'm one of your MCs for this morning, and I'm doing this with Senior Chinibuakodia TK, as he's called, who is here with me doing this particular event this morning. We are going to go to the first panel discussion, And the first panel discussion is on legal and regulatory framework. It's going to be for 1 hour. And there's a brilliant panel that's going to do that for us. And even a very, very, very brilliant moderator who will be leading us with the discussion. I'll invite the moderator, who will then in turn invite his panel members to do us the honors. Now, our moderator for this first panel used to lecture here at the Central University. He went to the Ghana School of Law as Director of Legal Education, and he is also a Court of Appeal judge or Justice of the Court of Appeal. Ladies and gentlemen, let's give Nana Yao Pomberima a round of applause. Thank you.
Her Ladyship, the former Chief Justice of the Republic of Ghana, the chairman for the occasion, my former lecturer, and one of the predecessors of the institution I also headed until recently. Permit me to start this part of the program being assured that my plea for standing on the protocols, as is usually said, has been granted. And I'm also delighted to be here, as Umaru has already said. Some of us, it's only a matter of coming back to our roots, because we were one of the pioneers, some of the pioneers who started this law faculty. Myself, the current Kisia Jabin, who is the special prosecutor, Dennis Jomo, Martin Pebu, Justice Siedu, and many others. So we are delighted to have been part of the beginning of this program at this faculty. And even so, when we have taken up other elevated positions. And so, luckily for me, I don't have to speak. So I'll call the panel members who are here to rise and join me up here so we can start the program. So I have the honor to invite Dr. Francis Kusiapia, Dean, Vice Dean, Faculty of Law, University of Professional Studies, Accra. Then also Professor Augustine Oklu, Deputy Director General, Ghana Tertiary Education Commission. And I understand that our third panel member is indisposed. So Professor Atifa, our Dean, has accepted to replace her, as it were, and to join us up here for the discussion. Prof, thank you. As they say, a lawyer must always think on his feet. So, and I know you can do far, far better anyway. So I'm grateful. I will make it very interactive. So I'll first of all invite each of you from Madam, ladies first, brief introduction of yourself, especially in relation to legal education, and then your general overview of the new acts, 1170, in 5 minutes, and then each of the others will also do so. Then we will take specific areas of the act, focusing on legal and institutional framework as contained in the act. So over to you, Madam.
Thank you very much, my lord. And I would also like to say thank you very much for the invitation. And I stand on all existing protocols as well. As my lord already indicated, I am Francisca Apia, the Vice Dean of University of Professional Studies Accra Law School. And in terms of the new legal education, I think this has come at a very right time, because there was so much uncertainty and so much confusion as to what is going to happen to the next generation of upcoming lawyers. It has come at the right time, but we have a lot to do. Just like His Lordship, the Chief Justice, indicated, this is a time for collaboration, a time to facilitate the implementation and ensure that we get the best out of what we have right now. It's not necessarily a time to criticize, but in as much as we are criticizing, we should criticize objectively and provide solutions to move ahead. So, for me, this is a very welcoming law which will transform our system, make us more competitive on the international market because it seeks to make some relevant changes. The introduction of experiential learning, although I must confess that the professional legal training as we have it already have some introduction of internship, but I think more can be done when we do a bit of comparative analysis to other jurisdictions in terms of experiential learning, legal clinics, hands-on training. More can be done. So this is an opportunity for us to explore. And for me, my role in facilitating the implementation is very critical because as the Vice Dean, we do more of the accreditation issues. So I'll end right here and hopefully would expand on other issues, my Lord. Thank you.
Your brief introduction and also your general comment on the act.
Thank you very much. I'm Augustine Oklu from the Ghana Tertiary Education Commission. I'm not a lawyer. I've not read law before. I don't think I've even read any book concerning law before. I'm a biochemist. I'm here as a regulator representing my boss, Professor Ahmed Jinapo Abdullahi, who is out of the country. So I'm also here to learn, and it is refreshing to hear from Our Lady the positives about the law. Personally, my daughter has written the law exam twice already and hasn't passed. So if I'm here today and the lawyers are telling me that the new regime is good, then for me, as a parent, I will be singing hallelujah. So when we were invited here, my boss forwarded the invitation to me and I started doing some preparation. Initially, I thought we were going to do some presentation, so I did some PowerPoint presentation. During that process, I must say that even before the law was passed, His Lordship, the Chief Justice, visited the Commission to have interaction with the Commission. And then about 2 weeks ago, we had a visit from the Director of the General Legal Counsel, also to interact with us as a partner in this whole journey. During the interaction, for us at GTEC, the only thing that we have observed, or the only new thing that we have observed, maybe that is what is going to arouse our interest, and that is going to change our current way of doing things, is the fact that the famous Mokola that everybody or every lawyer wants to go is going to be replicated in selected universities. So for us, under our mandate, as soon as a professional training is going to be done in a university, then we have to have some oversight responsibility. So we have to make sure that a university has the requisite system, resources, human, physical, and financial to be able to run that program. I must say that we already have professional programs being run in universities that we regulate. We have the Nursing and Midwifery Council that see to professional training of nurses and midwives. We have the Ghana Medical and Dental Council that also supervise the training of the medical and the dental doctors. We have the Pharmacy Council that is responsible for the training of pharmacists. And then in recent time, before the legal one came, we had the National Teaching Council that is in charge of teachers. So as a commission, we will say that we are experienced in facilitating and accrediting and overseeing professional training in the country. Again, our setup, I hope I'm not talking too much.
No, but
All right, maybe
except that I will really come back to you,
okay.
so you can actually deliver a summary of the paper you have prepared. So I'll just go to Prof.
Okay, all right.
To
Thank
also just give a brief introduction, and I know exactly what he can say if you also allowed him. So we will do so. We'll come back to you, give you more time to speak. But for now, introduction and your general overview. So thank you, Prof. We'll come to you. So you give us the biochemical aspect of legal training that we are expecting. Yes, Prof. Can
Moderator, I think it's working now. Thank you very much, Mr. Moderator. I want to stay true to the program. I'm stepping in the place of a discussant who is unable to join us this morning. My understanding of the role of a discussant is that the person listens attentively to the presentations by the lead presenters and then makes comments or offers a critique of the presentations. So I was beginning to actually enjoy what Professor Oklu was doing, hoping to get more flesh out of what Dr. Francisca would also contribute. So I think if we go that way, by the time it gets to my turn properly, I would have formed opinions about what it is, and especially because for me and my colleagues at the Central Law School, we're seeking guidance, especially from GTEC and from the Council on Legal Education and Training. And we also hoping for some synergies in terms of ideas from our sister institution, UPSA Law School. So we will wait and hear from the lead presenters and then offer a critique. I thank you for the opportunity.
Right, thank you, Prof. So, Doc, I'll come back to you. I mean, as a participant in legal education, can you take us through your own assessment of the legal and institutional frameworks that have been established under the Act, especially focusing on the establishment of Council for Legal Education and Training? To what extent do you think that your expectations have been met? Are there any opportunities for probably legislative amendments or maybe interpretation by the courts that will enable us to flesh out any areas that you thought should have been taken care of, but you can't find in the Act? So drawing on your experience in this endeavor, can you just, in maybe 10 minutes, take us through your own assessment focusing on institutional and legal framework as contained in the Act.
Thank you very much, my lord. So I'll take it from this angle, indicate what used to exist, and then hit straight on what has been presented by the Act.
Okay, go ahead.
So what used to exist in terms of regulation of legal training and the LLB or the law program was that GTech or the Ghana Tertiary Education was responsible for oversight, supervision, and accreditation. And often GTech would visit, but along with the members, some members of the General Legal Council. And their reasoning was very insightful, that they are responsible for tertiary education, for the LLB, but they lack the expertise in terms of law, so they'll come with General Legal Counsel. The new law, what does it provide in terms of the law program and then the legal practice, practical training? Sorry, just before I go to the new law, what existed for the legal professional training was that GTech had no connection. It was solely the responsibility of the General Legal Counsel overseeing the implementation of the professional legal training. Now, the Act 1170, what does it provide? Some few guidelines. So it has established a whole new council, the Council for Legal Education Training. And within that particular council, it has various reps. It has a rep from the superior courts, a rep from the lower courts. It has a rep from academia. It has a rep also from the Ghana Tertiary Education Commission. So they make up the board, or so to speak, the council. And their mandates, as has been stipulated under Section 3 of the Act 1170, are to accredit all law programs. And law programs, as defined by the Act 1170, includes the LLB as well as the professional legal training. So now it is referred to as the legal practical training, LPT. And in doing so, all universities under the Act, the structure is such that what will qualify you for a license for you to run both. So now we have the professional training merged with the LLB being handled by one institution, that is universities or faculties. So what would entitle you or give you the mandate to have or to run the law program? You need to apply for a license. The structure under Act 1170 is two-step. The first one, you apply for the provisional license. So the application has to be made to the council. And once the application is made to the council will set up a committee. And the committee now reviews your application to ensure that you meet certain requirements. What are the requirements? One, you are supposed to have certain infrastructural facilities in place. You're also supposed to have so physical infrastructure, and then the library, your library stock, relevant text, as well as digital versions of it. Again, you're also supposed to have qualified teaching personnel. Now you realize that because of the measure between of the measure of both the practical legal training and then the LLB, we are not just looking at what GTech would have looked at. Meaning, GTech requirement as it stands now, you need to have a PhD to teach in every tertiary institution. That's the basic requirement. But we are looking at legal practice training. If we are to go by that particular criteria, we are going to lose out on experts, practitioners. So under this particular requirement, the council has the mandate now to verify or come out, eventually the council will come out with details as to who qualifies to teach for the practical training, legal practical training. So not just the LLB. So we may have two streams of experts. One for the LLB, which will still be in line with GTEC requirements because the law has not been abolished. And then the second aspect, which would also enhance the expertise of practitioners, because we are talking about practical training. So we need the experts, the judges, lawyers who have rich experience to be on board. So once the council, the committee which has been set up by the council have already reviewed your provisional application, they will now grant, if it's okay, they send a report to the council. Now the council will then get back after review, if they are okay, approve a provisional license, which is just for 2 years. When that happens, 2 years you can run, you can admit. And in your admission, there are criteria as well. The criteria is there. You can admit, not necessarily with exams, but you have the option when you're admitting. So the debate about no entrance exam, it is optional. When you read it, it's optional to add when you're admitting people, whether for the LLB or for practical legal training. And then the second stage, once you have the provisional license and you are running, your responsibility as an institution is to ensure that before the elapsing of the 2 years, you apply for the full license. So, which is supposed to be 5 years if you meet the requirements. The same criteria applies. You should have met the responsibility of getting lecturers. So, student-lecturer ratio, the same as GTEC requires, will have to be met. You need library. And then, of course, you also would need the physical facilities. So this is the stage, this is the two parts application stage. Now, what is missing, or what I would suggest can be done, because in the interim, we have a transitional period. We are in a transitional period right now. In the meantime, before applying for the provisional license, a lot can be done by allowing those, especially level 400, to proceed to not necessarily what is level 500. I'm a bit hesitant to use level 500 because GTEC will now come up and say, who granted you the license to proceed to level 500? The universities have mandates to run short courses. And this is an opportunity for all faculties to make provision for those short courses. I mean the transitional period, the 1 year. When you look at the act carefully, I omitted to discuss the various courses that will be mounted under the legal practical training.
We'll come to those ones.
Okay, so I can stop now.
No,
Okay.
we can conclude on this. In any case, I will ask that you later clean this up and provide Prof with a full copy of what you have prepared.
Sure.
So we are just giving the highlights.
Oh, okay.
So if you can conclude on this, I'll go to Prof and then I'll come back to you.
Okay.
On a different matter, but related to what we are discussing.
Okay. Thank you. So I'll conclude with the transitional period. The transitional period will make faculty should be given the opportunity to train students in preparation for the implementation of Act 1170, which is the 1 year program. Thank you.
Right. And so, Prof, I will wish that your team will put together some of the suggestions. I'm addressing Prof directly, Prof Atifa. Some of the suggestions that are coming up. I wish that your team will put the suggestions together, maybe for presentation to the authorities. And this is a very key suggestion that has come out from our sister. And so I'm sure they will be taking notes. And then after they have presented it, we can together look at it and see how best we can also put the points together for implementation. Thank you. Now, Prof, in fact, the General Legal Council, until this act was passed, had a role which was recognition of institutions that provided legal education at the LLB level. The word used is recognition, whilst you issued accreditation. And I remember those two words came up quite strongly when we were trying to understand that, meaning the GLC and the GTEC were trying to understand their actual role. And so with this new act, in giving your presentation, can you let us understand, if you may, the role of GTEC? And interestingly, now a member of GTEC is also a member of the governing board of the Council for Legal Education and Training. So how do you understand the role of this council and GTEC? Where do the two roles meet, if at all? And where do they go their separate ways, if at all? Would there be a confusion in the exercise of their roles or performance of their functions? And being a professor of biochemistry and biological chemistry, is it? I'm sure you'll be able to dissect this aspect whilst you deliver your paper generally for further presentation to Prof. Thank you.
All right, thank you very much. So, you know, the current system, we are still training lawyers, but mainly the professional training is done at the Ghana School of Law. So you realize that the current system, GTEC really doesn't do much as far as the professional legal training is concerned. In fact, we don't accredit the Ghana School of Law. We look at them just like any professional body that is regulating the space. They are training their people how they should become proper lawyers. And in terms of quality assurance, quality control, regulation, as soon as you open up a space, then standard issue comes in. I remember when His Lordship was making the presentation, say, access shouldn't compromise quality. So before we have the Ghana School of Law, and we can all, chest up, beat our chest, and look, that is the premier institution training our lawyers. Now we have a system, a legal act, that has delegated that function to other institutions. And coincidentally, those institutions happen to be under our watch. So that's where we come in. There seems to be some merger, but in terms of implementation, we don't see a merger. So the LLB is not merged with the professional training. So in fact, when the current director of the General Legal Council visited us, he made a presentation to us. So as we speak, we, together with the General Legal Council, we see a 4-stage path to the Ghana bar or to the Ghanaian bar. The first is the LLB, which could be 2, 3, 4 years, depending on the institution and also the level of entry. And the second is the law practice training, which is supposed to be 1 year. And then the third is the examination, national bar examination. And then the final stage is called to the Ghana bar. So for GTEC, as my sister has indicated, we've always been regulating the LLB together with the professionals. So that is what we do. As a commission, we don't take decisions without input from the experts. Every program that we accredit, we have to get experts to give us their experts' view. Whether it is law, whether it's biochemistry, whether it's mathematics, or whatever. You go, the experts, we assemble the experts, they go and look at the program, they go and look at the facility, and they tell us that, look, this is okay, they can run a mathematics program. Based on that, we give accreditation. So we'll continue to do the same for the LLB, together with the body that is responsible. I think is the SLET, because there's a session, I've seen a session in the law, that's section B, 1170 section B, saying that CLET, in collaboration with the Ghana Tertiary Education Commission, shall set the standards for the accreditation of law programs in institutions. So they are going to continue to set the standard for all the LLB. So if you say law program, that is for the LLBs in this country. And they will do that in collaboration with us. Then we have the professional training. And I must say that for a start, in terms of implementation, we are most likely not going to have all the law schools running the professional program, because they may not all be well resourced to do so. So that's why the presentation that we had, they say, well, the 1 year law practice training with clinical component at selected universities, for a start, because we all agree with you, you are all lawyers here. You don't want to open it up too much.
Please, before you continue.
Otherwise.
Before you continue, Prof, hold on a second. We have expectation that Central will be one. Of course, the chairman school will also be part. So the rest, you can take a decision on them. We are fine. Can you continue, please?
So that is the current dispensation. So the commission is going to work closely with the Council for Legal Education and Training. As we speak, we are waiting for them to come out with the standards for the professional training. As soon as they come out with the standards for professional training, there are two things that we're going to do. As I've said, this is not the only professional body that we work with. So we can have what we call joint accreditation. We can have a joint accreditation where when an institution applies to run both programs, the LLB or the law program, and then also the professional, we can do a joint accreditation visit where we all see it and then we take a decision. We can also have 2 levels of accreditation. So we have accreditation for the law programs, which is in our domain. So in that case, we get the standards from the Council for Legal Education and Training, as we always do. We go in with their experts, we review the LLB, and we give accreditation. Then we leave the professional legal education and training to go and accredit the 1 year program. So that is also a possibility. Right. It depends on what. So for the other professional bodies that we deal with, especially the health professional bodies, they do their own accreditation. That's what they do. So the Nursing and Midwifery Council will give certification. And what we do is that until you get their certification or their accreditation, we don't go in. So you first of all get their certification. You submit a copy to us, telling us that you have dealt with them. They say you are well constituted. Then we go again with their standards. So to satisfy ourselves that what they say you have, you indeed have it, because we are supposed to be regulating that space. So that is, so there are 2 things that we can do: joint or 2 levels of accreditation. Thank you.
All right, so I'll come back to you. Especially so, on about 3 occasions, I was part of the team that went around to inspect facilities, especially library. Library means a lot to us at the bar. And together with members of the GTech, but I didn't really understand your criteria. What exactly you look out for in an institution that you have already accredited. So when I come back to you, if you can highlight exactly what, for example, you are going to look out for at Central University, that you have already accredited them, but they need to renew it, or for purposes of the running of the training program, your advice, now that you are here, you have to disclose everything to us so we can quickly go and fill in the form. And Madam, I forgot to add UPSA. I think you also qualify. Anyway. No, I'll come back to you. Prof, should I come back to you, or do you want to add something to it? Okay, Madam, so you mentioned accreditation, provisional accreditation before the final one. So if an institution is giving provisional accreditation and it starts running the school, and touchwood, the council is dissatisfied with the requirements, with the fact that you failed to meet the requirements, and therefore withdraws even the provisional accreditation.
No,
I think
that question should come to me.
Okay, no problem at all. Yeah. It's on the floor.
Yes.
Now, what will happen to the students who have already been admitted? If you can take this and also expand it, and then Madam can also give a brief discussion on that at the same time.
We don't have anything called provisional accreditation.
Oh, well, it's in this act. It's in this act.
It's in the new act.
Yes.
So we are referring to the Act 1170.
Okay, there should be what? Provisional accreditation.
Yes, for the practical.
2 years, isn't it?
For the first 2 years.
The first 2 years.
No, so okay, that is the term that has been used. But yeah, so we call it initial accreditation. Yeah, so it's initial accreditation, and for those who are running the law, you know that for every program we do 3 years. That's initial accreditation, and then subsequent renewal is 5 years. It's just simple reason that you are just starting. We may not want you to have everything in place before we allow you to start. So that is why we give you that initial accreditation for a shorter period, so that within that period you can put all the structures in place. And then, so normally you are even supposed to apply for renewal a year before. So in the second year, you are more or less applying for a renewal. But I think the good thing is that here they are talking of 2 years, because we are talking of a 1 year program. You are talking of a 1 year program. So it's okay to have 2 years, because by the time you are applying for renewal, you might have already graduated the first batch. So there's no issue.
So my point is, in your experience, for example, what you do, if you give the initial license or accreditation, I should say, and the institution is not able to meet all the requirements, and you need to take a decision to either suspend it or abolish it completely, what should happen to the students who are affected?
All right. So,
in other words, do you take? Hold on a second. Do you take the interest of the students into account?
Yes. So we always apply what we call teach out. Teach out. So the only thing we do is that if we have issue with you, we first of all suspend admission of new students. So admission of new students is suspended. And the ones in the system, you have a roadmap to teach them out. In extreme cases, like the normal, where an institution is affiliated, then we can ask the mother or the mentor institution to come in. But here, we are not going to be talking of affiliation. So the only thing is that, also, we are two regulators here. So if the situation is so precarious, we may ask for the transfer of those students. Right. But if we think that it's just some not too serious an issue, we will ask you to teach out. And if you identify that maybe you may struggle to teach out, we can also give you a support by getting you faculty and other human resource to help you so that the students that you are churning out would not suffer. You know.
So the key word is teach out.
Yeah, teach out.
Can you explain that a bit further? I mean,
Yeah.
So
the teach out is simple. Those in the system, train them until they go out. And as I've said, if we think that you don't have the capacity, because there is no way we are going to say sack those students. So long as they've been admitted based on the set criteria, they qualify to go to the program. If you think that the situation is so serious and that if we trust the students in your hands, they may not come out well, then we may get support for you or possibly ask another institution to take over.
Right, that's right. So, Madam.
So, thank you very much, my Lord. Just to add up to what Prof has said so far, under the new Act 1170, a similar structure. So the council will then give the, should I say, offending institution an opportunity to rectify. So they will do so through notices. And the institution would have the opportunity to either make representations or to rectify within some number of days under section 32, 33, and 34. So if you are still not able to rectify, that is when, just like Prof said, they proceed to the suspension. And even with the suspension, just like Prof has said, there's still the teach out opportunity before they proceed to cancellation. But immediately you correct within, under the new act, if you're able to make the necessary corrections within 30 days, your license will be restored.
Right, thank you. So can we also look at personnel, especially for the practical training? We all know that will focus on the practice of the law itself. And so can you give us some guidelines as to how Central University, or probably the decisions your school has taken, which you will not be allowed to keep to yourself? You have to disclose to us how you are preparing to attract the best from the bar and the bench in particular, and probably academia, but mainly focusing on the lawyers that have the experience, not only at the bar, but who can also teach. Because there are instances where you have very brilliant lawyers, but it's difficult for them to teach. So what are the guidelines you think you can favor us with as to how this institution can attract the best from the bar? Because we need people who can teach civil procedure, for example, criminal procedure, conveyancing and drafting. And this comes by experience at the bar, and also, so we need people who have experience at the bar and also academia. What is your advice to us? Prof is ready to take notes. Thank you.
Okay, thank you very much, my Lord. I think what we are currently doing is we are scouting.
Oh,
that's
right.
the truth.
Prof, please take
So,
note of that word.
We are within the transitional period. So the current act is gradually going to roll or move all those teaching the professional legal training on the various campuses off. So our first point is to attract those already teaching.
Well, we are here, the Ghana School
and
of
then
Law. Who serve as your consultant.
Yes. So those already teaching, and just like you pointed out, there are those also not teaching, but they are very good. So we are contacting a few practitioners, engaging them, and then asking them if they are interested, and judges, because this is procedure we are talking about. So civil procedure, criminal, AGs. So we are contacting everybody, but we are looking at least 10 years at the bar and above. Yes. Thank you.
Right. Prof, in your experience, how has GTech I mean, in terms of the other, managing the other professional bodies, as it were, how are they able to attract the best from their own profession? Let's say the Medical and Data Council. Can you share with us how they've been able to attract the best for their institutions?
Thank you. It has always been difficult, especially for the Medical and Dental Council. The difference there is that, to run a medical program, you need to have a teaching hospital. So in your case, I don't think we're going to say that to do a proper, you need to have a court.
Right. that has originally been the case anyway.
But it's something that, could be looked at. That makes it a bit easier to get people to easily, do the two. But even that, it is difficult. I know for the medical doctors, because the Ghana Health Service succeeded in improving their condition of service, most medical doctors don't want to go to the mainstream academics. So that is also difficult. Another difficulty is that they struggle with promotions.
Right.
As I think my colleague, sister was making a presentation, I think she mentioned minimum qualification. As soon as you become a minimum qualification, and then GTEC would say, would end the sentence, minimum for qualification is what? PhD. As soon as you bring that in, then you are getting the professionals out. So it's a conversation that we need to have. I'm aware the commission has constituted a committee that is looking at how in academia we handle the professional bodies, so that we should have a system where we can promote lawyers who are being, at the bar or for maybe a certain period, without having a PhD, for instance. Right. So those are the things that you can look at. But it is going to be difficult. You are going to have shortages. You are likely going to overuse some of them, especially the hardworking ones. They'll be moving from
like myself.
One institution to another institution, and then to have implication for quality.
That's right.
Yeah. Thank you.
Prophet, I think this is the time for you to also, in all fairness, also share with us your brief guidelines, so that Senior Sassari and Madam can also borrow. Later, I'm sure when Director Sassari comes up to give his final word, he will also share with us. The CJ spoke about collaboration, and I'll go to my next discussion will go into that. But for now, what do you have to share with us regarding attracting the best from the profession and your overview of what has been discussed so far? Thank you.
Okay, thank you very much. We convene this forum with the conviction that through the sharing of knowledge openly, we as prospective law trainers, practitioner trainers, and continuing academic LLB program offerers, that we will be able to exchange ideas, develop strategies for doing the things that we must commonly do, even if separately, but also things that we can collectively do, even within the broader framework of competition. And the Chief Justice gave us a lot of fodder for thought. For Central University, we believe that we are properly positioned. We are in 3 places: Mutual Campus, Christ Temple campus, and Kumasi campus. For all of these places, there are catchment areas in terms of lawyers and judges. For the Mutual campus, there are lots of lawyers in the Tema and in Tema and its environs. A lot of judges. There are people who choose to practice in those areas and hardly come to Accra. But there are also lawyers who are able, like your good self, my lord, when you were one of the pioneer teachers, you and Justice Osei Tutu and Martin Pegu and Kisie Jabin, Ferdinand Jazi, and all of these other judges, about 3 of whom are on the Supreme Court bench. You were traveling all the way to Mutual to teach day and evenings, long after class, after court. You were coming to our Mataiko campus. And it's because we had an incentive package that was good. We had ways of motivating you to see the value of imparting legal knowledge to students, helping to build a new crop of students and a new crop of lawyers who will benefit from your practical experience. And as a teacher, you get to appreciate the value of seeing your Umaru Sanda or I have a case in court where one of the first batch of law students is my lawyer holding the brief of Mr. Martin Pegu. Right. So the fact that the school you helped build, the school in which you taught, produces good quality lawyers from whom you can personally benefit, it's encouraging. And getting judges and competent lawyers to take on the business of teaching is one of the things that is most enamoring about this role. So I'm talking of an incentive or remuneration package that is competitive. Number 2, I'm talking about inspiring and encouraging judges and lawyers to see this sacrificial job, because no amount of remuneration will be adequate for some kinds of lawyers, such as some of you in the room here. But it has to be the love of teaching, even if you are not a professional teacher. Finally, we want to ensure that our facilities are top-notch, that when a judge or a senior lawyer comes to the Mataiko campus, there is a place she can relax, waiting for her class, that the moot court rooms are properly set up, very commodious, to make them comfortable, that there isn't just one moot court per campus, but that there may be multiple moot court rooms, and that we will have continuous and regular competitions, intra-school and inter-school or inter-institutional. Finally, the conversation that has gone on a bit has to do with the stages of accreditation, especially by the multiple institutions, the CLET and the GTEC. There are about 4 stages, in fact 5 stages in the accreditation process. I think it is neatly set out as first, the provision of a provisional license or accreditation lasting 2 years. If within that period you are able to meet the minimum standards that they jointly set for you, then, and you apply within a year, then you get the permanent accreditation. I call it permanent, but that's not the word the law uses, and it is for 3 years. During that period, they want to make sure that you have infrastructure readiness. So I mentioned moot court, clinical rooms, and those sort of things. You must have those ready. For us, that is one of the attractions. We've already started preparing for each campus several of these law clinics and reception areas and places where we can go to Abusokai, find people at the spare parts market who have problems. So women at Agbogloshi having contract issues at the market, bring them here with their real life conflicts and help resolve them as the law expects. That our students will be good clinicians, they will study under competent lawyers and judges, and they can make applications in court under the supervision of lawyers, competent lawyers. So that is the kind of preparation we are embarking on. Infrastructural, human resource, governance structures, the deans and the administrator and the finance officer as the law prescribes. We are taking steps to get all of these kinds of arrangements in place. Finding well-motivated lawyers and judges to come on board is going to be the biggest challenge. But we believe that at our 3 campuses, we can come to the Supreme Court and Court of Appeal and the High Court and get eminent lawyers and judges like your good selves and Mr. Forson Jr. here and others to come and help.
Oh, he's here. Okay. I didn't
come over to Macedonia and help us. So that's the we are embarking on. Everything in the book, in the law, we're crossing them one by one. We're working on a strategy that will go to management on how to meet every single one of the items, have a checklist and benchmarks and go with it.
Right, thank you very much. So we'll come back to you for your last take, but may I respectfully invite the general public to bring some opinions, questions, queries, short contributions. We are going to close in 15 minutes. And then, but before then, let me also say that what Central started with in terms of attracting the best actually reflects what Senior Ansasari had started. People found it quite strange at the time that lawyers who had not been in academia had been tasked to teach at his school. But when you review the results, he can tell you that was the best decision to take. And so when you also invited us subsequently with the same approach of drawing experienced lawyers from the bar and the bench, not necessarily having PhDs and so on, really work with. And as I can say that because I'm familiar with the results, Central has been among the best. And so I'm happy, but the word there is cash. As they say, we don't take sales to the market. We take cash. And that's why he said the medical doctors are not attracted to teach. But we also add sacrifice, even though sacrifice alone doesn't take us to the market. So with all due respect, we are now inviting you. Omaro, approach the audience. If any of them have questions, queries, contributions, you are excluded because I've seen that you want to open your mouth to say something.
My Lord, I was going to pray that I don't have capacity to ask the former CJ for a comment, but you have some kind of locus. So if you could ask that, she comment on this matter.
Well, the former CJ is also a king. I don't want to say a queen. So be careful when you're approaching the king.
I withdraw, my Lord.
All right. My lady, will you be comfortable if you don't mind? Our king, if you want to sit down for us. Before we are asked to come to Akropong to perform some sacrifice. Is that right? Thank you.
You're forgiven. I don't really have much to say. I came here this morning learn and to get myself ready in my role as the chair of the advisory committee. But I am very happy that one, it's going to be now possible to have a continuing stream. If you get into a good law school, you can come out as a fully fledged, trained professional. And it is interesting just how challenging the next few years are going to be as some law schools and faculties run with it and others do a waiting game to see if they can follow. I'm hoping that, and I'm expecting that Central Law School will be one of the pace setters.
Amen.
Yes, and then as we go along, setting the pace, Mount Crest will be follow.
Mount Crest will follow. They may want to lead it.
Yes, so that's one reason I'm very happy for this program and this particular program, and I'm hoping that Central University will organize a couple of similar ones as we crystallize the direction, because at the moment there are more institutions waiting to see and few institutions ready to take the bit in their mouth and run with it. Thank you.
We are grateful. Umaru, can you pass it to the gentleman on the right-hand side the left-hand side of our king,
Mr. President.
the man in bow tie. He's one of my mentors. And Prof, I'll disclose to you where his expertise lies, because some of the people who have become lawyers today were lawyers because of the work he's been doing for us. But I won't say it here, otherwise they will inundate him with better deals. So later I'll tell you. So my good friend, Mr. Forsen, somebody said means the son of Mr. Four.
Well, thank you very much. I wasn't expecting.
Please, if you don't mind, you can.
Oh, my Lord, let me stand.
You have sat down for a while, okay.
No, my Lord, let me stand. Because I'm sitting next to the former Chief Justice and my lecturer.
Don't forget.
So I think it is a bit disrespectful to also sit.
Yes, okay, that is fine.
I'm a stickler for discipline and ethics. I was talking to my lady here about the issue of bringing up quality lawyers in respect of discipline. In respect of discipline. So I'm just praying, because Central University is a Christian-based university. So I hope that they will shape the morals of the students such that when they get out, honing their skills with the morality will not be too difficult. Because I sit on the disciplinary committee of the General Legal Council, and I was telling your ladyship the kind of stories which come there, the kind of cases which come there. It's a bit heartbreaking. You wonder how they came out as lawyers. In fact, I always jokingly accuse Mr. Kujeto, who sits on the disciplinary committee, that these are your students, because he taught ethics. He taught me ethics. So any egregious case which comes, I say, Mr. Kujeto, this is your product. Then he will say, but you are also my product. I say, I'm the exception.
They would have left the law school long before they picked up this unethical behavior, because, so blame the chambers.
I will concede. I will concede that the chambers in which you practice also shapes you. But I would think that more of the work must be done in the faculty, because it's habit. Yes. For example, I don't take people based on CVs. I take people based on recommendations, so that if somebody comes, I know it's Prof's reputation the person has to protect. But it can't go on like that? What about those who don't know anybody? One of my juniors, who is Mr. Dennis Ama, when I interviewed him to be in my chambers, I asked him why he wanted to be a lawyer. And he said, oh, he comes from Kede. And his mother is a teacher at the agri training school. His father is also a lecturer. And he realized that when people had issues, they had nobody to speak for them. So he decided to be a lawyer. The interview lasted about 5 minutes. Then he said, oh, he's now realized that if you work hard as well, you can make some money. I said, that's the kind of lawyer I'm looking for. So that this is a person whose interest is protecting people's interest, not the money. And trust me, if you work hard, the money will follow. It's like night follows day. Of course, the grace of God, the recommendation of some judges and your own colleagues when they see you are doing well also helps a lot. But if you hone your craft according to how you are taught and what the law says, you can never go wrong. So my concern right now is based on the quality of the lawyers, as my lady was infamously noted for when the 127 people passed. And when she said law is the profession. In fact, a lot of people make fun of that when they see said the law is the profession. And I concede that is why everybody is flocking to be a lawyer. And when you travel, I just came back, when you stand in front of an immigration officer and he sees that you are a lawyer, they treat you differently, which means a lot is expected of you from the society. So my greatest plea will be to most of the lawyers around. In fact, when I'm still on the bar counseling, but I always pray that the bar executives should go around the law school and share their experiences with the young ones as they come up. Because sometimes they come up with some expectations which are not real. And it didn't happen anyway. But I try my best. I was telling my lady here that I try my best in my own small way when I get either a cluster of students or young lawyers to show them the way. But if everybody were doing that, I believe that the profession would be the better for it. But I will encourage the students that learning doesn't break any bones. In fact, I always famously say that I was referred in legal taxation. And I had a case against Mr. Jejan, who was my lecturer. If you look at the law reports, IRS versus multi-choice. And he was on the other side. And the vim with which I did the case, he himself was impressed and was happy that this is a product of mine who has been able to defeat me. You know, that's the joy that the respect is there, but we might agree on a point. I will share my last experience before I sit down with my own lecturer and master in chambers, Mr. Kwame Tete. There's a provision in the CI 47 about where a petition is filed. They said a petitioner on whom an answer is filed has 14 days within which to file a reply. And after that, pleadings are deemed to have closed. But the question is, when a cross petitioner files an answer on the original petitioner, the rules are silent. The rules are silent. And I had an argument with my former lecturer and boss. He disagreed vehemently, but at the tail end, he said, the rules must protect both the petitioner and the respondent. So if the petitioner has that right, the respondent equally must have the same right. And he said, I hope your client is paying you a lot of money. I said, this is an academic point. But it's interesting, and that is how we develop the law. So I will just pray that hone your craft, and you will never feel shy in any court. I hear there's a seminar going on with your colleague that the law school teaches you the law and the courtroom teaches you all other ethics. So I will pray. Now the explosion, I don't know how the law firms are going to take in all these students, but I pray that somehow we are all able to cope with the flood of students using flood intentionally. Thank you very much.
We are grateful. Very much grateful. Now, yes, our former director.
Thank you. My lady, former Chief Justice. Moderator, one issue that must be of concern to the legal profession is the attitude of the current youth towards examination. Honestly, for me to hear a student ask, "Inti afi a bachelor entrance exam ana?" And my immediate reaction is, why not? Oh, director, I tell you, if we encourage the youth to be apprehensive of examination, we are likely to end up producing half-baked lawyers in future. And I say this unashamedly because, to be able to get the best, there must necessarily be an assessment. An assessment is through a vehicular means, and that one vehicular means is examination. If we remove the bar and allow just anybody to enter the profession, we are going to have charlatans in future, and that will be a very expensive price for the nation to pay. It will take us many more 150 years to rebuild what we have inherited from our seniors. I'll give you an example. When I was appointed a teaching assistant in 1977, my lady had returned from Harvard and was teaching equity. Yes, a former Chief Justice teaching equity. And it was a joy to associate oneself with, Mr. Michradia, baby, so for Kufu Chradia, no, because that was the name. Kofi Kumando. Today, we are not interested in that. All we are interested in is the one question: entrance examination. I think that this panel and Ken should reconsider this whole issue of examination if we mean serious business. Removing examination from the cluster of things that the law school, will do us more harm than good in the future. My next is from what Ken suggested, taking a cue from the Chief Justice. We need to build bridges, but the rivalry amongst us, that sometimes I shared a concern with Ken many years ago as to why Mount Crest and Central shouldn't be able to exchange faculty. So if he's teaching criminology and I don't have that expertise, why not? But the rivalry, and sometimes I don't understand it. I should be able to go and teach contract at Central. You should be able to come and teach land law or something, and then we crisscross. But we are not, so we lose expertise in the process. Now we are organizing this thing. I asked Ken, why don't you organize many more, like my lady said, so that we also follow? And I'm very happy that a private institution is leading the way. Not Legon, not Tech, not Cape Coast, but Central. And Central was born, how many years ago? I believe Central is in their 8th or 10th year now, the law school, isn't it? And Legon is, many years ago. These are the sort of things that, should be done. And then finally, what Tony, said, the young ones now believe that when they are called on Friday, they should be referred to on Monday as legal luminaries and be able to charge.
Gurus.
That should stop. So discipline must be our watchword. And discipline will begin with when the intending lawyer knows that the entry will be through examination, not at the end. At the end, everything will go haywire. At the end, said national exit exam. No, it must be the beginning and at the end, win out. So when you are called to the bar, you know that you are a lawyer, worth your salt. Thank you very much.
Thank you very much. Umaru, time is running out.
Yes,
so
I also have 2 prayers to you respectfully. The first prayer is that you, at your discretion, decide the last person to speak before we take the other panels, because in those panels we will open the floor up, so you could decide who next you want to call. My other prayer is that you kindly allow me to acknowledge 2 personalities in the audience. Right. First of all, your mentor, we haven't properly acknowledged. So, Mr. Former President, we are grateful that you joined us, Mr. Anthony Forsin. Thank you so much. And then my lecturer, he taught me jurisprudence and company law, Dr. Baden. Please give us a wave here at Central University. Francisca Kakra Forsin is my colleague at CTFM and Channel 1 TV. She's a big woman in the Central University scheme of things. Please give us a wave. And then Dr. Bafo Boni, not the one who left us a short while ago. This one taught me contract law here at Central University. He's currently deputy at the Commission on Human Rights and Administrative Justice, Shraj. Dr. Bafo Boni, thank you so much. My Lord, you may proceed. Thank you so much.
Thank you very much. So, Prof, there is a call to establish Center for Legal Colloquium. I've been very much aware that names personify. And so the word central is really positively affecting you. So you may have to set up Center for Legal Colloquium, where occasionally we'll be here to listen to experts for the advancement of legal education. So since we are running out of time, may I come back to you, just give us a summary. And as I said, in due time, if you can make available to us your full papers, which will be published. I think there may be a legislative instrument to this act. So whatever suggestions that come up probably will be helping Parliament or the institution that will be responsible to come out with it to do that job. So I was going to ask that you be the last, if you don't mind. But if you need to
just
chip in
a
something.
small bit of information
Please go on.
What you just said. In 2015, Central Law School established a law magazine, a law journal called the Magna Carta. It was in celebration of the 800th anniversary of the signing of the Magna Carta. It is a publication we intend to activate, and this colloquium and the presentations and pictures and all of that would be the basis. We are also going to have actual papers that we elicited from the call. Those abstracts and papers are actually fully developed or fully fledged papers are also going to be published in the magazine, which will be a celebration also of scholarship, not only within Central University Law School, but also other sister law schools. And this cooperation that we are initiating will blossom through the pages of the Magna Carta. Final point, to assure our students, especially, we've developed procedures and mechanisms, one of which we are going to hone through the advisory board, through committees, special committees of the Central Law School, to tackle all the different angles of the accreditation process, all the different angles of enhancing our scale of preparation, so that when the roll is called up yonder, we will be there. Thank you.
Thank you so much. So, Prof, your last word, but particularly on how to ensure that the act is not weaponized to create a class system that we currently have. We have class A schools, class B schools. In fact, once your daughter goes to any of those schools, when somebody asks and I says, oh, then your daughter is already in the university. But she has just started SS. But just because of the school she's in. Now, anyway, my lady, she's in Wegehe. It's your credit. Now, so how are we going to ensure that this act will not be weaponized to create another level of class system where many people will rather go to a particular school to do the practical training, which will eventually then lead to other schools being tagged as level 2, below the standard. And Madam, Doctor, I'll also come to you. So, Prof, for your technical advice in brief, maybe 5 minutes.
Thank you. I was thinking that you should rather provide an answer to that question.
Oh, no, it's easier to ask questions than to answer them. So,
because, as I've said, this is not the only professional body that we deal with. So I think the overall goal and the long term should be that when you enter a law school, you come out as a professional lawyer. Well, that is what is done with other professions. You don't go to a nursing school somewhere and go and do professional somewhere. You don't go to a medical school somewhere and go and do professional somewhere. So that should be the overall goal. And that can only happen when institutions are ready. So am I going to have another, or this is my last?
Okay, just summarize everything for us.
So the success of this and the quality assurance must start from the institutions. That's the only way. You shouldn't see the regulatory bodies as enemies. We should collaborate. If we want quality lawyers, it has to start from the classroom. We shouldn't have a situation where, in recent times we complain about nurses. Who are those training the nurses? We are training the nurses. You go to an institution, they will tell you the facility you have, you should admit only 30 students. The next moment, they have 100 students. You go to some institutions, some would even present ghost names to you as their faculty members. Oh. You turn your back, the people are nowhere to be found. So, I would say 90% or 80% of the success and the quality assurance in the legal profession will be the institutions, the universities. So if in 10 years after this legal act, we all start complaining, blame yourselves, not the law.
We hear you.
Thank you.
Okay, thank you very much, Prof. We've taken up the burden. But 10 years' time, we will not be blaming ourselves. We will just be happy with what you've done so far, positively. Yes, Doctor, can you just conclude in brief?
Yes, my Lord. I'll take it from the creation of some schools, classifying them. So what we can do, I believe we have the Conference of Law Deans. And so far, code, yes. So far, if you look at the Act, some courses have been taken out. That's right. In order not to have different versions of law being taught in different schools, I think it would be great to have a unified curriculum development through code, so that whether you attend Central, you attend UPSA, Legon, it is the same material, the same structure, nothing different. And I also believe that we can help ourselves by collaborating. We are talking about clinical legal education. Some are far advanced when it comes to clinical legal education. I was excited when Prof indicated that Central has also taken initiative. Now, UPSA, we've not just gone ahead to just create the center. We have inculcated it in the curriculum. So there's a structure for implementing the clinical legal education. I believe we can share so that we can learn from them. They can also learn from us. Library resources and technology. I think that can also be shared. That's right. Because digital materials outside, we have universities collaborating such that LexisNexis is across all the universities. That's right. They are sharing so that we reduce our bills. I think that can also be done. In terms of teaching, yes, we have issues with getting the number and the quality of lecturers that we need. But I believe that so far we have an understanding with GTech. They've understood the fact that law is a specialized program. And on that basis, and particularly with this particular law, we are now going to have some measures or criteria in place such that, look, in as much as we are saying we will start with practical legal training with maybe lawyers, we are suggesting lawyers 10 years and above. If you are capable of teaching with some master's degree, you can go ahead and try adjunct positions to start building your capacity. So capacity building, I believe, is very necessary as we go along for continuing legal training. And of course, we are going to have overloads in our transition period. If we are even supposed to, there are over 4,000, I'm sure more than 4,000. So UPSA cannot take all. So I think we can still collaborate. The numbers, share. Central can have space. UPSA may not have space. We can still share. And the last point I'd like to make is this act is a great initiative, but I believe that GTech and the new council should come out clearly as to what it means to be accredited. The reason is that if one party accredits you and the other party has not accredited you, you are still not licensed. So that should be clarified in maybe an LI or so. Thank you very much.
Right, thank you very much. On that note, Nana Emrahim, that's my lady's tool name. Thank you very much for allowing us to go through the process up to this stage. I have learned a lot from the act, but two things. So first, especially from what Senior Forsen said, ethics. I think at this level, I know some of the universities have started, legal ethics should be a course, compulsory course for everybody, right from the beginning, the first year. And you can spread it throughout, so it becomes a way of life. And then number two, we need to also remember that all the schools coming out, we have a mother, the Ghana School of Law, the prestigious Ghana School of Law. We have the personnel. You just have to come around. We will help you to get some consultants. Of course, I mean, with some reasonable remuneration. I'm sure they won't leave the Ghana School of Law, but they will be quite resourceful to you. So, Senior, you won't find it difficult because most of them you taught, you were their director, including myself. So, on that note, we want to say we are very much grateful to you. So, we'll be leaving you in a moment. But please try and wait. There are other exciting programs coming up. And may the Lord bless and keep us. Amen.
Thank you very much. Your Lordship, ladies and gentlemen, let the applause reflect the insightful presentations and contributions by the presenters and those who contributed. Now, we have come to the health break. And these are the instructions. All judges and invited guests, you are heading to the VC's lounge. judges and special guests invited. You are heading to the VC's lounge. Please, ushers, assist us so they will find their way. All advisory board members will be at the holding area within the VC's lounge. All advisory board members will be at the holding area within the VC's lounge. All deans and directors and staff of Central University will be at DI2. And the multi-purpose hall is for all students. I could read that we have 15 minutes, but by reason of the fact that we are going, we are in short of time, so if we could do 5 minutes instead of the 15 minutes and then return, so we can have the next section and then go for lunch. Otherwise, we may have to skip lunch, and I don't think that is what we want to do. So please, let's take the health break. Within 5 minutes, we should return for the discussion by the second panel. Thank you very much.